NDPS, Mr. Mullah, Council Hearing. Sixth. Item number 30. Yes. Wait for a few minutes. Just after the mentioning, we'll pass the order. Wait for a few. 16. From which police station? Yes. Mr. Botakur. Have you received the CD? File to wait for a few minutes. We'll pass it after some time. Yes. Okay. Yes. From which police station? Mr. Botakur, you have the CD? When the order was passed, calling for the CD? Port. Till port. If it is not defective, then tomorrow. Yes, got it? If it is not defective, yes. Tomorrow. Yes. Yes. Repair of proceedings. Yes, ma'am. Yes. On repair the council for the party, leave this matter on 6th of June. Yes. Yes. What's your prayer? Wait for a few minutes. We'll do. Wait for. Which item? Listed today? Not listed. For tomorrow. Give them in. Yes. 13. Yes. That in presence of the 20. 9th. 9th of June. Disposal. On instruction, the petitioner, Mr. Tenhoff, Land Council, sorry, Tenhoff is not pressing this criminal petition. For regular petition. Stand dismissed. Well. The benefits for Yes, you want to withdraw. What's your good name? Hi, you are appearing on whose behalf? Hmm? Okay. Sir, you go counsel appearing for the petition and Mr. P. Botapur, Digital Public Prosecutor appearing this day. Since 10/04/2025, Secretary of Hemaji Police Station, case number 33 of 2025. By order, it is second Secretary of Hemaji Police Station is called for. But in spite of granting time on 23/04/2025, 15/05/2025, they say that if that could not be placed before the by Mr. Botapur and as Mr. not been to the public prosecutor. The concerned investigating officer of another police station, case number 33 of 2025, shall constantly remain present before this court 10:30 a.m. on 9th of June. This is BS on 6th of June. The up-to-date case. Spelling. No, like, no, one more matter from this court. Which this police station, which item was that? This police station. No one. But this but I think yes, which I instruction on the petition. Mr. Jamun also is not pressing this. Remain petition. To which Mr. Botapur. Or Mr. President. Protected. Also referring to the petition. And Mr. Botapur. Special public prosecutor. Wildlife and forest. Forest. On instruction on the petition. Mr. Petroleum. Mr. Bhattakur, don't have to have the case diary, because I've already been recovered. Just get the report, okay? Not prepared at all. From Pokrajar. Tell us. Today is 27. Report. Get the report. Just report the from the IO. Mr. Bhattakur, same from Viswanath. We are fixing it on port. Get the report. Get the report. On port. For port. Is it? Give the number. BA. 112. Yes, next. It's okay. Bhattakur. Bhattakur. Just the microphone is on. Yes, Mr. Manta.
Milad, here, the challenge relates to the proceeding that was taken cognizance of under section 138 of the NI Act. I have challenged it on more than one grounds. And you see, firstly, in the complaint, Lordship will find I am residing outside the jurisdiction of the court. Firstly, when the alleged accused resides outside the jurisdiction of the court. Nowadays, under the this Bharatiya BNSS. It is a requirement now to make certain investigation. Otherwise, no. And accused should be heard now. These provisions are not complied with.
But this is a case of 2022, before the BNSS came into court.
This was filed when? 22. So cognizance was taken under CRPC. Is it? Huh? CRPC. Yes. Yes. So CRPC has been invoked here. In that case also, Lordship will appreciate 204 before issuing process. When a person is outside the jurisdiction of the court will be very slow in going ahead. But my question is here, to initiate a proceeding under section 138, the requirement is that a notice has to be served. Here, at page 36, Lordship will kindly see. page 36, the order by which the cognizance was taken. Here it says that the check was presented at complainant's bank. Notice was sent to the accused but returned without being served. A categorical finding. Notice is a must and it has to be served. Mere issuance is also not enough. Because then only the rest jurisdiction comes to file a complaint. This complaint would not have been filed, and when the court found that notice could not be served, without being served, it was returned on 5/5/2022. And then the court went ahead to hold that on perusal of the postal track as a consignment vide number such, it appears that the notice sent to the accused was out for delivery on 19/2/22, but returned for addressee not being found. Court has gone to that extent also, but again found that not addressee not found.
Mr. Kumantal and senior counsel. Assisted by MS and Ahmed counsel appearing for the petitioners. So heard Mr. P. Bhattakur and additional topic for appearing for the state respondent opposite party number two. Opposite party number one as complainant. File a complaint petition before the superficial magistrate P2 at Karbiano under section 138 of the LI against the petitioners being CR case number being NI case number 04 of 202. Mr. Mantal and a senior counsel placing the complaint relating to said NI case number 2022 submitted that the accused persons in the said complaint petition are not from the district of Karbi Anglong and a resident of Guwahati. Mr. Mahanta also placed the order dated 19/05/2022 passed by the Chief Judicial Magistrate Karbi Anglong Dipu, showing that the notice issued to the accused persons that the petitioner's hearing, though was out for delivery on 19/02/2022, but returned for addressee not being found. And the learned 12 magistrate, without considering those aspects, came to the conclusion that notice have been duly served on the accused petition, accused petition hearing. Have been duly served on 19/02/2022. And without following the due procedure of section 204 of the CLPC. In spite of having the knowledge that the petitioner and the accused persons are outside the jurisdiction of Serbia, to cognizance of the offense under section 138 of the Interim. Procedure taking place and issued summons. Hence disciplinary.
No?
It's a notice. Returnable by 23rd of June. As Mr. P. Waterford and additional public prosecutor appearing for the state opposite party. Petitioner shall serve with the text of this criminal petition have given access to Mr. Waterford with more opinion. Petitioner shall take state for such petition to the opposite party one by registered court with
Further proceedings may pending.
providing is corrected for a pitch with the stems. On or 28/05/2025. Subject to taking steps on the rest of opposite party as directed. The proceeding of NI case number such and such. Pending before the court of land, chief judicial magistrate. Carving law at the court. Then may suspended. Till the returnable date by 23/06. Let's review.
The equal lordship, my lord. This is demanded a similar matter. The lordship is well aware of it. The lordship has already passed an order on 21/5/2025 on similar matter. But if further proceedings of the pending in the court of the land, Sirang State, I just get a copy of the order. The lordship passed an order, man.
Yes. What is the check number?
But check number is, my lord. Page 37, my lord, Annex 5. Page 37, Annex 5. Check bearing number 485-264. For rupees 2,20,000. And my lord, my ZDA entry number that I reported to the line. That is on, my lord. Page 4. Para 6. The loss of the Sheikh was duly reported by the son of the petitioner, Sahanur Ahmed, at Tadalgaon Police Station, and a general diary entry by GD number 27 was registered on 15/10/24. And in this regard, the police gave a police report dated 8/4/2025. And the second question, same order, my lord. I give the lordship. Apply. Case number will be different, my lord, and I see a case number 11/2025.
Take step.
My lord,
Steps by tomorrow. Subject to taking.
my lord.
List along with, what was the first case? This was the first case or there was another case?
This is the fourth case, my lord, we have been,
No. This series of you have, what was the first case?
this is the second case, my lord.
List along with it. Hello.
In criminal petition number 580.
What was the
that is
first petition that,
580, 2000, criminal petition number 580,
it was the first case?
25. That was the first case, my lord.
Baki get the list along. Okay.
Highly obliged, my lord.
Take steps by tomorrow.
Obliged, my lord.
Slightly reversed. But for 28 application of it, for the amount of vehicle of it.
Mr. Bothakur,
Yes, ma'am, I will get the report.
get the report at the earliest.
Yes, ma'am.
When? Vehicle was used for illegal transportation of cattle.
Yes, ma'am.
Just find out. Search it file,
Yes, yes, check it as
so at this place whether it is required, definitely not required.
Yes, ma'am.
Any order, did you approach the?
Yes, yes, Lordship. Lordship will
Where is
find
that
the
order?
impugn order at page 19, Lord.
Why it was rejected?
Lordship, it is
Before
required
filing
for
the search sheet,
Lordship.
before filing search sheet or
After filing such in Lordship.
after filing search sheet, whether search sheet was before the court?
Yes, yes, Lordship.
Where is your Zima application?
Lordship, application of, I have not annexed the application, Lordship.
Did you annex?
I have
No.
annexed the order, Lord. Annexed E, Lordship.
See, you could have, you have a certified copy of it?
Yes, yes, sir.
What are the items that you have claimed?
One vehicle, Lordship. So if desired, Lordship.
The order says it is deemed that the claimed items are necessary. It is not about the car
Not
or
only
not
car,
the
Lordship.
vehicle that was.
Yes.
We do not know from this order whether the particular car was what was Zima or not.
Lordship, only calls for the record, sir.
We will not call for the record. It is your duty, your case. You have to establish your application. Why should you call for the record? You get it, certified copy, then we will confirm. Cannot come like that. Your brief is not proper. Don't check it, don't accept it. All the parties will have the certified copy of the application. Yes, sir. Placed on
Oh, I couldn't.
12th of June. On the said date, the petitioner shall place the certified copy of the application for Zimma of the vehicle seized in the case. Seized in NDPS case number 202 45 of 20. In which the Learned Additional Chief Judicial Magistrate Dhamati rejected the claim of the petition for the sake. On the said date, the investigating officer of Dhamati PS case number such and such present depending to Koti Court of Learned Additional CBM Dhamati as PRC number 98. Shall apprise the court of the requirement of the seized vehicle of the petition.
Currently, customer the matter for typing logic. And his counsel is
Yes.
court number 18.
What is the matter about now?
Actually, this is one transfer matter was petitioner filed in FIR, lordship, in, see, file in one, case, in,
What is the order?
actually, I am not, the exact case not sheet.
Because
FIR is at page 10, ma'am.
Page number 10, Lordship, annexure 1, FIR.
Number 2 मतलब
I apologize, madam.
it's okay. Yes, what do you want? What is the prayer?
Well, my first prayer is that to uh, call the status of the that newly numbered, I don't know the number, but
How do you know that he has been transferred to Kodapur?
because I personally went to the all women police station and asked them, and they informed me that it was transferred on, my lord, date is also given in the already. I personally, my lord, being an advocate, I personally went there. Prior to that, my lord, the complainant informant went there twice or thrice, and she had been informed by the police that whatever would be the
Based on fifth. And I'm bringing Mr. P. Thakur, additional public prosecutor. To apprise the court about the status of Old Woman Police Station case number 163/2019. In which the status of the petitioner hearing was the concern informed. Get the information, then we'll.
Obliged.
5-6, madam.
6.
May I please allow you? I think this criminal petition is under section 528 of the EMS, whereby the order dated 26/2024 is being challenged, passed in CR case number 6792, oblique 22/22. Lordship, in this case, this case is under section 138 of the Negotiable Instruments Act and has been initiated by the petitioner for dishonor of two checks, that is amounting to 78 lakhs and 83 lakhs respectively. Now, Lordship, in this instant case,
Other cases pending
no, Lordship,
between the parties,
no, Lordship.
sure?
Sure, Lordship. Only the trial is being proceeding right now. So, Lordship, in this case, what has happened is that once the accused entered appearance in the case and denied the matter, Lordship.
Vikram. Yes.
Lordship. So, Lordship, once cognizance was taken in the case, thereby the accused entered appearance and denied the allegations leveled against him. And upon that, upon pleading not guilty, the provisions of 143A was attracted. Thereby, Lordship, an application under 143A was preferred by the petitioner and which was rejected by the learned court. Lordship, may kindly peruse the order date, kindly peruse page number 38, Lordship, of which is the impugned order, Lordship. Page 38, Annexure 4, Lordship. If the Lordship comes to page number 39, the last paragraph, Lordship, if I may read, I've also perused the case record thoroughly, and upon such perusal, it transpires that no case for exercise of discretionary power to grant interim compensation to the complainant is made out at this, as the accused has taken a plausible defense during the stage of offense explanation, wherein he had categorically denied his signature on the two checks in question, being Exhibit 1 and Exhibit 2, and also denied the receipt of Exhibit 5 being the legal notice. when the signature of the accused itself has been denied by him in the checks in question, I do not deem it fit to allow the complainant's prayer for grant of interim compensation, Lordship. Now, Lordship, thereafter, Lordship, we are before this honorable court being highly aggrieved by the said orders, because Lordship may kindly peruse page number 23, Lordship, of the petition, Lordship, page number 23. Now, what transpires from the said document, that is basically the check written memo, Lordship. If your Lordship kindly peruses the check written memo, page 23, it states the reason for dishonor, and that is funds insufficient, not signature differs, Lordship. Moreover, with regard to the second check, page 22, Lordship, page 21, Lordship, similar ground of, sorry, Lordship, page 24 and 23 are both the check written memos. Both the checks have been dishonored, not for the reason signature differs, Lordship, for funds insufficient. That is the reason, Lordship. Now, the order which has been passed, considering the case that there is a plausible defense taken by the accused person, prima facie, Lordship, that itself is a blatant lie, Lordship, because these are evasive denials taken by accused during the trial, Lordship. But if the reason would have been something else, some other explanations would have been provided, that could have been taken into account. Now, the court prima facie forming an opinion that the signature is different and the accused is denying it, but the document is stating otherwise, Lordship, which is a document given by the bank. And Lordship, it is as per the banking policies which are governing this country, Lordship, first of all, when a check is deposited, what is seen by the officials is the signature, first of all, which thereafter they access the account. Before checking the drawer's signature and the check, they cannot access the account of the drawer. So the whole plausible defense which the learned court is relying upon is itself an evasive denial, Lordship. And such evasive denial cannot be taken to be considered for passing an order under 143A. And moreover, Lordship, the Honorable Supreme Court has also.
Okay, that's also.
Lordship.
The petitioner is a complainant. File a complaint petition before the on the chief judicial notice to come on the section 138 to 142 of the NIA. It is the response here. Or default of payment of 2 checks. Issued on 23 and 24.
Lordship.
The checks are issued on 21 and 22.
Lordship. 15/9/22, Lordship, and 10/9/22, Lordship.
Monthly to the 78. The 10/09/2022. And we get it. See, seeing it. There's some by Mr. Charles Council appearing for the petition that the learned judicial magistrate first come to court. In their case number 36792-204. Illegally rejected the claim of the petitioner for interim compensation. Ground that the respondent, the country, to agree that he did not issue any subjects to the petition and also denied that check in, sorry, that the signatures in the in those two checks involved in the case. No, Mr. Das, counsel equaling to equity. That the respondent in its affidavit filing the state and case number simply took the ground of evasive denial of its signal. And considering the check belong methods to rejected the claim of interim picture. Interim report. Mr. Das also placed for the court the two checks issued by the expert. Copy of the and the report of the bank, Union Bank. Dated 11/10/2002. Clearly reflect the reason for non-payment of the amount mentioned in the check as funds are insufficient and not because of mismatch of the signatures of the respondent. Being agree with the said order, the chief judicial minister first class come to party. Dated 20/06/2024. Passed in staircase number 6792 of the 2024. Rejecting the claim of the petition for interim compensation. Issue notice returnable by 24th of June. Petition is right to take this, accept the full response by registered court. Providing its cover. Call for a eligible scan copy of the records of staircase number 6792 C on report of law. Judicial minister. Sorry, judicial make the first class. Come up metro court. The interim pair of the petition shall be considered on the returnable date. And these are the purpose on the sole response as well as the list of we register the petition. List of
Deeply apologize.
Made to you. The petitioner has sitting bail. In relation to the question box case number 35 of the 24, which is pending with an honest special judge looking in connection with the affair, which is at page 14. Lost by the page 5. Thereafter, matter has been subsequently committed, and presently the trial has been going on. And I have annexed the copy of the my lord statement accorded by the learned court below. Relation to the PW one as well as the PW two file. The lordship take note of the statement of PW one. There is the victim, which is at page 29. So far her statement made before the investigating authority, which is at page 20, madam. May kindly we take note of. Page 20 is the statement under 161. Page 2, 161 statement. The facts and the story narrated before the investigating authority is different to that of the facts and circumstances which has been deposed before the learned court below during the course of my crime. Now, my lord, take note of the my lord statement of the PW2, who is the doctor, examine the my lord. As per the report of the my lord doctor, she was above 18 years old. That means she is not mine. Page my lord 32 is the statement of the doctor. So far the statement of PW2 is concerned, the it is appear that she is more than 18 years old, number one. Number two, no such alleged offense was found in a body as per the opinion of the court. And so for the statement of victim girl is concerned, she herself deviated from her own statement made before the investigating authority as well as before the learned court.
Yes, ma'am, have you gone through the record?
No, you're not.
Okay, you go to the record, both of you go to the record. Okay, let's. Mr. Sharma,
My lord.
to take it up on some other day, let him go to the record. If you also want to go to a record, go to the record.
Yes, so let me be.
Monday next,
Fine.
go to the record. Go to the-
Obliged.
Wait, please, Your Lordship. That's a regular bail, my lord. Well, here the point involved, my lord, that is 50 of the CRPC. Before that, my lordship have a look at page 19 for a once, my page 19, my lord. Page 19. There are two names, my lord, Mohammed Asimuddin Bonia and my lord Syed Khan, Abu Syed Khan, my lord. Well, I am for Mohammed Asimuddin Bonia, my lord, and that Abu Syed Khan, my lord, have been granted bail, my lord. Can I pass the order?
You're appearing for whom?
Your lordship, NCP.
NC.
Your lordship. Yes, we are paying for adjournment today, your lordship.
It is some earlier calculated. Kindly allow.
They have already filed the affidavit, my lord,
Kindly allow us.
and my lord, the same order, my lord, that I have,
Therefore, tomorrow.
that may be kept as a part of the record, that order.
So it will be in the record.
My lord. The same, and it was granted by court number.
You have, kindly allow.
Please, your lordship. My lord, the petitioner in custody since 6/11/2024, my lord. The FIR is at page 14, my lord. And statement of the victim is at page 26, my lord.
You are appearing for whom? What's your good name?
Vinny Raj.
My lord, the statement of the victim is vital, my lord, page 26, my lord.
Mr. Burtik. What do you have to say?
Your Lordship, your victim is a minor. She has been traumatized by the act, and therefore I pray before this honorable court that the accused may not be granted bail.
Yes, you can read SME.
Okay.
You can read SME.
That's it.
Can you read Bharan? Can you read SME? Okay. Guru. You have read?
Yes,
Give it to her. Charge have been framed under section 366A, 376(3) IPC and section 4 of the Previous Act. What are the ingredients? After reading this 183 BNS. Is there anything?
366 scale or you are the minor one or
Oh, he was minor and he was major, fine, to that extent. That's it. The
rest part is,
what about 376(3) and section 4 of the Previous Act?
that is not indicating as part of first statement.
Hmm? What is her statement? You have just read section 183 BNS.
Not sure.
Is it there?
No. Not sure.
Yes.
And charge
Now,
pen,
charge have been framed under 366, 344.
376 dual 4 of those.
These are the charges. Go on. And there is no medical report.
Yes, sir. But she was recovered from Bangalore and that one taken to her parental house. So no medical was done at the time.
So that is the reason I'm asking you. If this charges are framed against the petitioner, the basis has to be the some materials in the charge sheet. Now, where in the charge sheet those materials are there? Whether the victim stated so, maybe a minor,
That's
right? But there are some materials, medical report or other. What is the inducement in her statement?
no, no.
Charge. Definitely. Those materials are before the court. Now you have read one PP.
Not.
Okay, that. In this is the background, what to do.
Only thing is that he was stated that he has stated that 5 lakhs rupees was given up to take admission in a coaching center. That may be a factor. Only thing is
You
that
have read, that's why you are not saying anything. Yes, ma'am, kindly tell us. True, she is a measure, she was only 14 years, some days on the date of the incident. But the reason she has passed two talent examinations, but her father did not allow her to take admission.
Yes.
And if you think that on the basis of these materials, the charges that have been framed are sufficient, you consider your submission. Make your submission after going to the record. That's all we can.
Only I was
The victim, there is no letter in her statement 183. Except 366A, right? What are the others?
What? my humble prayer before your lordship only yes, charge paper 28, 325 lordship. And out of 10 PWs, no one is examined yet.
make your submission on this, the charges payment, then we'll consider it pay. Right? No, because he has been charged with this section 6 of the POCSO Act. Section 4, section 366A, IPC, 376 3IP. And section 4. So section 376 IPC and section 4 PSUS Act. If it is not under PSUS Act, then the thing will make your submission in that account, go to the records and tell us. When?
Monday next month.
Sure. Mr. Bora,
Yes, ma'am.
both of you go to the record. And they have the form. Yes.
Oblige me. My lord, can it be some other day except Monday, my lord?
Monday is not possible. Court.
Yes, my lord.
Court?
Yes, my lord.
Okay, I'm sorry.
Oblige me.
Yes, Mr. Sekia.
Item number 18 and 19, same FIR.
Same FIR मतलब 18, 19 मतलब तो FIR is a case मतलब 10 मतलब.
You are in custody since when?
I mean custody since मतलब the 5-3.
Commercial quantity, my lord.
Commercial quantity मतलब whatever it is मतलब they
You
have.
have the FSL report?
No, my lord, actually.
When it was forwarded?
Yes, my lord, I will contact you. As per my lord, last note on 11/2/25, on 11/2/25, forwarded to Directorate of Forensic Science, Kaili.
Total quantity?
Quantity is my
Mr.
lord,
Sekia?
मतलब quantity मतलब from him it is मतलब 19 point some kgs.
my lord, total
Total-
from the
total-
35.850.
35.85 मतलब 0.85 total मतलब from 2 persons. But they have been the
From their joint possession.
Wait for some more time. Let it be in the next week. Right?
No.
We'll have some. Mr. Botafoot,
Yes, my lord.
tell us when you look, I'll give it.
My lord,
Since you have sent it in February, probably it has already forwarded.
yes, I will try to get it, my lord, on 12th of June.
See, the reports are available with the Superintendent of Police. As per the submission made by the senior government advocate Assam. Because about sometimes in the month of March or in the first week, after March, I think it is in the after view. There was an inquiry made, pursuant to an order of the court from the FSL with regard to such FSL, with regard to the forensic report. We wanted the forensic department to tell us the number of cases pending, how they took forward the report. They have categorically stated the reports are sent by email to the concerned SP. Yes, there are direct access between the forensic laboratory and the concerned SP. There are specific website where they can do. And it is reports are sent to the, not to the police station, but to the concerned SP. And probably the IO has not collected the report from the concerned SP.
I will get the instruction.
Tell us the earlier by 9. Last on 9.
Yes, on 9th of June.
This one 9.
Well, on, my lord, it not 9th, my lord, 9th on Monday, my lord, it would be probably on 11th of June.
11.
11.
11.
My 11. 11.
List on 11, allowing the investigating officer. 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 11 of GRPS case number 36 of 2025. Regard to the official report. Both 19 and 18.
18 and 19.
18, 19, right?
18.
Yes, ma'am.
19. Number get it.
Okay, this is a procedural matter, and we have taken a step upon responsibility today itself.
You have not yet taken.
Today itself, we have taken.
So the order is at 1305-2025. The petitioner has taken step beyond the 19th of June, enabling the officer in charge of Gosaivam Police Station to apprise the court report pertaining to subject of notice on the respondent number 2. Not respondent, opposite party number 2. Complainant. Mother of the minor victim. Go ahead. Sorry, father of the minor victim.
Second application, my lord, earlier lot rejected by your lordship, my lord. He is in jail from 382 days, my lord, as on today, my lord. POXO matter, my lord. Last of the occasion, my lord, we have taken step, my lord, for officer in charge, my lord, to the informant, my lord. And record also come, my lord.
Report might have come with the steps written to the.
Awaited, my lord, as per office note dated
You have
22.
taken steps only on 15th of May.
15th of May, my lord.
At least 1 month time we have to give to the respondent.
Chemical. I am not on merit in this case, my lord. Only on the ground of, my lord, the notice under section 50 and 50A was not,
Look into that, but
My
only on the duty
my
service of public.
my lord.
June. Officer in charge of Dotuma. Chapter Dotma. UTM. Dotma. Yes. Chapter Respond number 2. Father of the neighbor.
Yes,
Application, my lord. It's mainly the basic ground in each case, my lord, and non-compliance of the section 50 of the CRPC corresponding to my lord
47, 48 various. That case victim, he was therefore does 10 months languishing in jail, minor. Charge sheeted out of 7, 1 witness has already been examined, minor. Yeah, the total point 296 gram of heroin. Commercial point 250 minor. Was traveling in a train over the sum. Having received information, minor. The informant is stuck, reached at a New Bongaigaon, minor railway station.
Well, section 50 is complied with, my lord. This is there in the report, my lord. Section 50 of NDPS Act.
Though the notice 50 is my lord conveyed to the petitioner. But
And because, my lord, he was, my lord, apprehended in a running train, my lord, and he tried to clear away from the spot, my lord. And at that time, my lord, he was arrested and that is complied, my lord. I have flag mark, my lord. Or Mr. I'm contemplating for the petition. And Mr. P. Sharma. And additional for the prosecutor reporting for. Petitioner namely Chatha. I'll take the petition and check for it to be. Paying for it. Special. In the narcotic. 03 in the command. Rising up of your case. Trial of the critical should be put forward. Detailed access. Input. He was arrested on 27/07/2022. And the earlier this court rejected the bail of the petitioner. In, do you have the case number? Okay. Mr. Ahmed, do you have the case number earlier by which this case was rejected? You don't have? The, take it. You have not stated on two occasions earlier you have filed bail application. On two occasions.
I'm sorry, I'm extremely sorry. I'll have my lawyer withdraw this petition, my lord. I'm not pressing my. I'll file appeal by my lord.
It's okay, because if the petitioner doesn't inform you, how will you know, Mr. Tahir?
I'll like to withdraw my lord.
Or Mr. F.K. Rahman, counsel appearing for the petition. At least you have to state that bail petitions are rejected if you can always come. There is no bar.
My lord,
But thing is, there has to be a
I'm
statement.
extremely sorry, my lord.
And it's okay, Mr. Tahir. Probably you are not aware of.
No, we are not pressing.
Or Mr. F.K. Rahman, counsel appearing for the petition. It is. And Mr. B. Sharma, additional public prosecutor appearing. The petitioners earlier on two occasions filed bail application for his bail. In Bongaigaon, JRPS case number 87 of 20, being bail application number 3197 of 20, and 370/2025.
3197 only, 2000.
3197/2024 and 370/2025. That way. The petitioner did not state about such bail applications moved by him earlier before the court. For this. In the present petition. However, you will have a pitch on both the occasions. There are differences of answer. Mr. F.K. Rahul, counsel appearing for the petition. Tell us that you are not aware of. And it's not present. So it's Mr. P. Sharma. Listen. At least mention it.
Yes,
and
ma'am.
move to it.
I'll file by the lawyer.
Also, the bail petition also earlier rejected the second bail application. This can copy was called for. I today come against the notice lordship under 47 and 48 section PNS lordship. Regarding I related document I said okay. It's 23 for notice. 23 and 24.
Mr. Sharma, have you gone through?
Yes, my lord, gone through.
Okay, there's no.
Lordship, with some order, my lord, so far all the things except the checkbook 47 and 48. When he was arrested,
Lordship, 10 August 2024. To be 295 days, 210 days.
That's are wrong and it counts like 40. And next one, B Sharma, additional public policy. Petition and English of research. Well, it's application under section 483 and 033. String 43. NDPS case number 113 of the writing of the filter police station case number 257 of the 204. Which trial against the petition. The progress under section 22 into the C of the NDPS. Corresponding to the case of 61. 8, which you are taken into custody on 10/08/2024. Apprehended and then custody. Earlier, the petition approved with court. In bail application number
3008.
3008 of the 20. The court of considered. So going to the relevant record. By order the 29/11 to the rejected the bail for the it said NDPS case. That it in this bail application that the concerned investigator while arresting the petition on 10/07/2024 did not comply with the provisions of section 47 and 48 of the PNS and thereby violated the provision of Article 22 of the courts have the petitioner that office will take NDPS case on I think that's not good. There is the record of the case of NDPS case number 1 and 3. The records of this. So, it was called for by the 13th. On special people, the brief facts of the case, the special people and specific information. On 21/03/2024 around 01:00 AM. A search was conducted. The house of the petitioner. At Varenga Part 2, Oman. And the Silchar police station. By the authorized police personnel of Silchar police station. Following the due procedure. In presence of independent witnesses. And recovered 380 bottles of Hincock, PK, suspected to be contraband cough syrup, each bottle containing 100 ml, and also a sum of rupees 12,500, along with one Maruti 800 vehicle, bearing registration number F11A0270. However, the petitioner could not be found in his house, and he left it, coming to know about the presence of police personnel in its said house. They seized van of syrup along with the vehicle and the cash recovered were seized by preparing seizure memo. Thereafter, the FIR was lodged before the officer in charge of police station on 21/03/2024. According to said recovery of 383 bottles of Hincock van Hincock PK of syrup and contract. The cash amount at the very start. Accordingly, Silchar Police Station case number 25/2024 under section 22 within C. The NDPS Act. The FSL report dated 22/07/2024 of the seized substance in the said Silchar PS case number such and such. Confirm the same to be confirm the presence of protein within the as protein phosphate. After the said FIR, dated such and such, the petitioner was awaiting arrest. The petitioner could be apprehended only on 10/07/2024, 10/08/2024, around 11:30 PM. And he was produced before the learned special judge, NDPS, Pachar Silchar, on (11/08/2024). On completion of the investigation of the case, Sarsit and said Silchar case number 257/2024 was submitted on 31/08/2024 by charge sheet number 800/2024 under section 22C. Negative TNT case against the petitioner. Well, on a special death, NDPS. Pathar sensor on 21/11/2024, frame charge under section 22. C, in bracket C of the NDPS against the petitioner. The submission of the site, third sheet. Insert PS case number 30 on section. The same was registered as NDPS case number 113 of the 20. State seizure case. For 8 of the 20. It on 3. Six months. The record of the case which is approved. February, May. Nineteenth of May. So that the prosecution have already adduced evidence of 6 of its witnesses out of eleven named prosecution witnesses in the section. From the records of the case, it is seen that at the time of arrest of the petitioner on 10/08/2024, in Silver PS case number 30. That one Rizal Hawk Law Score related to the petitioner was present and he signed the arrest memo. As relative of the state, relative of the petition. In addition to the above, from the records it is seen that notice under section 48 PNFS was issued to say Rizal Hawk Law Court, relative of the petitioner, informing him that The petitioner has been taken into custody in Silchar PS case number 257 of the 2024 under section 22 within bracket C of the NDPS Act. And that he shall be forwarded to the Honorable Court of Chief Judicial Magistrate Kachar, Silchar. A copy of which was duly received by State Reservoir of Glasgow. From the records of the case, it is also seen that notice under section 47 BNF was issued to the petitioner informing him that he has been arrested under section 22C the NDPS Act in Silchar PS case number 257 of the 2024. And the same is non-bailable to police. From such notice under section 47 of the 48 PNHS issued to the petitioner and his related at the time of arrest of the petitioner. It is seen that petitioner has been duly informed the section under which he has been arrested and that the same is not bailable by police. And further, his relative was informed that he shall be produced before the Chief Judicial Magistrate for its production. Please report it at the 1547. The notice under section 47, as well as 48 issued to the petitioner by the concerned investigating officer of Silchar PS case number 2572024 as available record. Be placed as follows. Mighty. Painful. From the perusal of the same and on reading of section 47 and 40 of the PNF, it can be seen that the concerned investigating officer did not comply with the provision of section 47 and 48 of the PNF, and thereby violate the provision of article 22 of the Constitution guaranteed to the petitioner. And written by the Honorable Apex Court in the case of COVID production. Yeah. We have switch on the microphone. It's on.
Let him watch. Sorry.
The fact of the case is that, my lord, on 28/11/24, my lord, a vehicle was intercepted and seized by police, my lord, along with some petroleum products, my lord, that is petrol and diesel. My lord. And it has been alleged that those were smuggled from Bhutan, my lord. It is the incident of 28/11/24, my lord. And thereafter, my lord, on 7/4/25, my lord, we were arrested allegedly with a vehicle, my lord, and 24 number of empty gallons, my lord. No petroleum product were seized from our possession, my lord. So my contention is that, my lord, though theft is there, my lord, no one has complained about theft. And regarding import, storage, and, my lord, transportation of petroleum product is concerned, my lord, there is a special act, my lord, to that regard, my lord. That is Petroleum Act. My lord.
Yes, Mr. Votak.
Yes, my lord,
Considering
here
they
the
are in custody since 7/4. do you
yes,
think they
yes,
should
my
be
lord.
considered?
Otherwise, here, my lord, yes, here main allegation of all these accused person is that, my lord, these accused person actually, my lord, illegally collecting, my lord, petroleum product, that is diesel, my lord,
They were
petrol,
going to Doranga Mela to collect.
my lord.
As
And
per
thereafter,
this-
yes,
Right.
because price of, my lord, all these petroleum products is.
You understood, but here, the petitioners were apprehended when they were proceeding towards Doranga Mela to collect.
Yes, the present two petitioners, my lord, and thereafter
But
some,
They were not found with any sort of,
thereafter on the basis of their statement, my lord. Yes.
otherwise, the thing is,
Otherwise, yes, empty gallons were recovered from the present petitioner and on being,
I think for that from 7th of April.
yes, my lord, sufficient, sufficient. Your lordship may.
Sufficient or more than these two we found. And what about the other? Tell us.
Regarding other, my lord, person.
He is the person from whose house those things were recovered.
Yes, yes, on the basis of the present petitioner's, my lord, statement.
And regarding in item number 32, from his possession, my lord, oil gallons containing diesel oils, 12 numbers, in each gallon, my lord, 35 liters of. my lord,
Right
petroleum
from the same FIR of the 2811 to the.
Yes, my lord. Initially, FIR laws on my lord 28/11/24. At that point of time, 3 persons, my lord, Paresh Baru, Biswajit Baru, and one Ranjit Mandal was arrested. Thereafter, my lord, regarding that type of offense, the incident in going on and during investigation later on, my lord, after 4 months, these accused persons were arrested. So, my lord, in that case, my lord, these persons
They
were
have come together.
yes.
Lordship,
The incidents are different.
incidents are different, Lordship.
Incidents are different because my lord, offense are of same type and this type of incident.
On 28/11, Lordship, Naka checking was conducted and the case was registered. On 7/4, also Naka checking was conducted. These two accused were apprehended with empty gallons, and on their statement, my house was searched. So these are two different incidents, Lordship. And the diesel is much below the permissible limit, Lordship.
Permit the issue of preparing. BF. Mr. Keyboard, let's go. Petitioners being leave, offense of 1. Well, the application on section 4 playing 43. Tamako case number section. Corresponding to GR number 1004. In which they were arrested on 0704 to the. Initially on 28/11/2024. The retained FIR was lodged before the Tamilpur police station. That during Naka checking, and area petroleum at Tamilpur Medical Store, PH Portal. When an Omni and bearing registration number AF 01W9745. It was coming from Dimla Park, PIN, LAPAR, towards Tamilpur. Was signaled to stop. It played it. To stop. On being chased, the vehicle was apprehended. And while it was checked, the accused persons present there were found carrying petroleum products illegal. That's it. Like 13 gallons petrol, each of approximately 30 liters, and 6 gallons of diesel, each approximately 30 liters. Suspected to be smuggled from the Potomac. First, on being led by the apprehended accused person, the police personnel from Tamilpur Police Station reached house of another accused, and when it was searched, we found huge quantity of petroleum products such as 10 gallons of petrol, approximately 25 liters each, 11 gallons of diesel, approximately 30 liters each, and 1 drum containing approximately 100 liters of diesel. All the 3 persons were apprehended. The petroleum products along with the vehicle, only vehicle, the seized. The said FIR was accordingly registered as Tamilpur Police Station case number 300 of 2022 under section 111 within bracket 2 within bracket small oblique 303 within bracket 2 oblique 317 within bracket 2 of the PNS 203 section 7 of the essential. During investigation of the said Tamilpur case number 3300 of 2024 on 06/04/2025, a vehicle bearing registration number AS01BM2806 will apprehended and on being searched, implementing articles like gallons were found in the accused persons, i.e. the petitioner's hearings, admitted that they were on their way to Doranga Mela to collect diesel. On interrogation, they named one Sabikul Islam of Doranga Mela police personnel from Tamilpur Police Station, along with those two, along with the petitioners, conducted a search in the residence of Sheikh Sabikul Islam and found large quantity of petroleum products. From his house, we could see after they were taken into custody on 06/07/2025, the petitioner produced before the Lana Chief Petitioner Chief Petitioner Minister Mursalpur Paksa. And since then, they are in custody in said number 2 case number 300 of 2. On procedural of the case, there in considering the period of the granting the petition is 07/04/2025, the court is of the view that further custody claims of the petition is offered for investigation of say Tamilpur PS case 300 of 50,000 each, the inspection of the land petition and safe judicial magistrate. Then part Mr. Amran and counsel for the petitioner and Mr. P. Waterfall and additional prosecutor for respect. Apprehending his arrest, Mr. Satan Patel. From the FIR. Mr. Waterfall, just tell us what is the amount that was recovered from the house of the petitioner?
My lord, amount not recovered from the house of the
AB,
what are the liters of
liters,
petroleum
yes, oil gallons containing diesel oils, 12 numbers, and in every 35 liters approximately in each gallon. 12. That is in in page 12 of annexure B of the petition.
It is around 1020 liters, Lordship. Below the permissible limit.
Total 12 gallons, my lord, in each gallon 35 liters.
Once Mr. Andy Dutta,
And my lord, 3 drums containing diesel oil, my lord, 200 liters.
fine, once Mr. Andy Dutta placed a particular provision.
Yeah.
Of the petroleum product, think next time. The how many liters you can have in your residence or open space without having a license?
Yes, and I will try.
There is in the.
2500 liters, Lordship.
There is a provision in the
Petroleum,
maximum.
without having any license.
Mr. Arnold and the council appearing for the petition committee. That. He procured the petroleum products in his house inside Tamil Nadu. By paying money on 05 to 04 to 025 and 06. Right. From an Hindustan Petroleum outlet. To that extent, the petitioner has annexed the payment houses pertaining to reported. Condition. The petitioner shall appear to the concerned investigating. On. Second of June. Then after. You have the medical report?
Medical report, my lord. My lord, one medical report is available in the case diary regarding cause of death, my lord.
Because certain police personnel were injured. That is why.
Oh, sorry, my lord. Sorry, my lord. Item number 26, my lord, case diary and injury report not received, my lord. Injury report not received, my lord, 26.
From Dolgaon, Mongoldo, how much time you take it to Dolgaon? Tell us when.
My lord, on 7th of June, man.
Okay, 9th of June.
Yes, ma'am.
Or 11 case of Dolgaon case number. Take before of it.
Correct.
Yes, Mr. Potter. You are an interim.
I am interim on 4% Lordship out of 6.
For 1 and 2 are not granted.
Pardon?
1 and 2 are not considered.
1 and 2 are not considered under the lordship. One is a woman lordship, she has a 3 years old child lordship.
See,
And
what is
2
it?
is a businessman, mostly CD has come.
Yes, sir. It is.
You are appearing.
Appearing for the income.
Okay.
I have already filed.
Otherwise, my lord, the persons who are in interim, my lord, they appeared statement recorded.
What about 1 and 2?
Regarding 1 and 2, my lord, because entire year, my lord, case of the husband died on 4/12/24.
The thing is this, she was having an illicit relation, that's why she was
Yes,
to procure
madam.
money, that's what.
Yes.
The case there, what about 1 and 2? Because
Uh,
two are the persons,
1
right?
and 2, my lord, there are, my lord, some of the witnesses stated that yes, there is some relation between the, my lord,
Is that enough for?
no, my lord, that is, my lord.
497
The case diary,
lordship.
it reflects, otherwise, because everything is on suspect. Otherwise. So, my lord, let them appear and cooperate with the investigation, otherwise, custodial interrogation, my lord, may not be necessary. From the, my lord, materials available on record. my lord.
Lordship, another thing that during lifetime of the husband, he never complained. All the incidents are of April 2024 lordship. He died in December.
So what about the property, the assets that been procured by the particular accused number 1 and
Regarding those things, my lord, it is very difficult, my lord, from the case they also to ascertain, my lord, that these are the properties, my lord, on the basis of which, my lord, by using those monies of the husband of the present petitioner, those were, my lord, procured, my lord. This is very difficult. From the, my lord, case diary also, my lord, there is cannot be straight, my lord. Very difficult to ascertain, my lord. Because some of the allegations really made that these are the, my lord, properties.
whether any for bank transactions and other.
Yes, one of the, my lord, two bank statement available in the case diary of the present accused number 1 and 2, because there is nothing pointed out, my lord, regarding long, my lord, transaction. It is difficult for me to point out everything, my lord. Well,
So nothing from the bank account of the PC,
otherwise, bank statement available in the case there.
whether any fund has been allotted to the from the.
It is difficult to say
No,
from
no,
those transactions.
Yes, Mr. Sharma, you can
Okay,
only
point out
assist
to
the
you
public
by-
prosecutor as you know.
Matter is serious.
True,
Because
have
they are very serious problem.
True, it happens. The
Ah.
thing is this, the
And
person has expired.
FIR, but actually, they conspired and he was last, suspension committee. And that's why, since I am the widow,
True, but thing is this, everything happened only after the date of the husband.
yes, it. That up to 4 months, lordship. No doubt. But the serious are very, allegations are very serious. Furthermore, I would like just point out one thing before your lordship. The in the common petition, right, it's common petition. Your lordship may see the affidavit. The only general statement, which how the petitioner number 6 has all the information. He is the head of the family, lordship. No, Hazrat Ali is the head of the family. All are family members. 2 sons, 2 daughter-in-laws, lordship. But no case of 406 at all. Even 420 cannot be made out, lordship. Actually, he cannot be involvement of the other. We are in the same family, lordship. Residing in same house. And this woman have a 3-year-old child, lordship. So here, it also appears that I am sorry to say that FIR is not properly translated.
Here, one medical certificate of death is available in the case diary. I would like to.
Of the deceased,
Yes, ma'am.
So why? It is a normal death.
Normal.
At this stage, lordship may not Actually, and he is not a layman, he is a government employee, Lordship. Deceased was a government employee, DC office employee. Deceased no more.
If at the time of death, my lord, any complaint would have been lodged, then my lord, postmortem, etc. could have been done.
And there may be some custody intervention. Before your lordship, I just want to point out something that must be up to your lordship. That is very not attract. That we see. We will avoid by any condition, lordship. But in the meantime, they have also cleared the place from Nagaon to Panchagatra, Moirapari.
But Mr. S. K. Poddar, please take it. Learned counsel for the petitioner. And Mr. P. Thakur, learned additional public prosecutor appearing for the. Also heard Mr. A. K. Sharma, learned counsel appearing for the informant. As per the FIR lodged by the informant, grade 2404 to 2004 to 025. The accusation against the present petitioner by the informant is that since 2020, middle of 2020, the petition number 1 with the help of the other accused petitioner conspired and took a huge amount of money and other assets from her husband who expired on 04/12/2024. FIR 2004. In the said FIR, the informant also alleged that the petition number 1 was having illicit relation with her husband and the family members of the petition number 1 was fully aware about it, but did not stop her as the informant's husband during his lifetime was blackmailed and took economic benefit from him. The said affair of the informant dated 20/04/2025 was accordingly registered as Nagaon Police Station case number 238/2025. Six. लिख दिया under section 61 within bracket 2 oblique 318 within bracket 4 oblique 316 within bracket 2 PNS 2023 corresponding to GR number 9/3. Mr. Thakur, under additional public prosecutor, place the relevant case there of Nagaon case number 33. On 1905-2025, accepting the petitioner numbers 1 and 2. The rest for petitioner. Number 3 to 6 granted interim bail. Mr. Kotaku Leonard Count Religion Working Committee on obtaining such interim bail. The petitioners number 3 to 6 appeared before the concerned investigating officer of Nagaon PS case number 238 of 2025 and their statements about. Mr. Botaku from the case study also submit that the statement of the independent witnesses so far recorded by the concerned investigating officer of the case did not implicate the petitioner of the accusations as alleged in the said FIR pertaining to Nagaon PS case number 338 of. Considering such materials indicate the interim bill granted to the petitioners are here. Number 326, namely submitted on 1905-2025 in state North of the subject to the compliance of the purpose. Say. The petitioners number 1, namely subject and the description process shall appear before the concerned investigating officer of North on or before 3rd thereafter the condition.
Keep your.